Hi viewers, welcome to the Personal Injury Show. This is a show that deals with everything to do with personal injury law today. My name's John Karantzis. I'm a partner at a law firm in Victoria that specialises in personal injury law. With me tonight I have two special guests, James Richardson, an associate and an expert in work cover law. James.
Hi John, hi Don, hi viewers.
And Don Maffia, an expert in transport accident law in Victoria. Hi Don.
Good evening John, good evening viewers.
Viewers, tonight we've got a very interesting episode on work cover and the medical panels, how they operate, how they can determine your work cover claim and how they could also finalise your work cover claim.
But John, before we get to that, let's talk about what's in the news.
Oh Don, there's a lot in the news again this week. First things first, compensation for a cancer claim. Now, James, what's this all about?
This is an interesting matter, John. A party who was exposed to toxic fumes in a welding company has been able to successfully sue for compensation under the Victorian work cover legislation.
So his name is Mr. Tran. He arrived from Vietnam in 1988 to Australia.
That's
he was
correct.
working in a welding shop in Clayton South, Don.
No masks, John. No ventilation, so pretty much closed room.
Yeah.
And the court heard that welders have a 23% chance of more likely to develop cancer.
And he's developed this cancer, and it's a lung cancer.
Yep.
And it's almost fatal. He's lost his lung.
Yeah. He's actually, the right lung has been removed, surgically removed.
He's lodged the work cover claim, and the Victorian Work Cover Authority have rejected the claim, astonishingly.
Yeah, look, John, this goes to show that, look, I mean, you've got these fumes on welding. When an employer has a duty of care to look after their own employees, as simple as buying them a face mask or even just providing something, open the door or something.
Well, the evidence was there was no face mask given to him in the first year of work. He was working in these closed conditions. In the winter, all the windows were closed. So he was breathing in all the fumes, James. And, well, he's developed his cancer. Work cover, the Victorian Work Cover Authority reject the claim. He has to take it to the county court, spend thousands and thousands of dollars in litigating the claim. The county court judge finds in his favour.
That's correct, John. The plaintiff was able to successfully show that they were on the balance of probabilities that the carcinogens that the plaintiff was exposed to had caused the cancer.
So that allows him now to obtain weekly payments of compensation, medical expenses, and opens the door for lump sum compensation, doesn't it, James?
That's correct, and this opens the door for many other parties who have been exposed to similar sort of carcinogens.
So I guess the moral of that story, James, is you think you've suffered an injury at work, you need to pursue it.
That's correct. Okay,
Don, a mine operator knew the risk of death before this event. What happened?
This was in a quarry, so you had a worker on an excavator working on one area, and it was a lot of rain the night before thereabouts, and the employer told this worker to move to another area, which, as it turned out, there was a landslide and pretty much drowned the worker in dirt.
Yeah, he asphyxiated.
The employer should have known that area was also unsafe.
Now, the fine to the employer is about $1 million, isn't it?
That's correct. Because all the evidence showed that the employer knew or should have known that area, in fact, when I looked at the area, so that area no one should have worked in.
There's
That's
a
how
lack
bad
of,
it was.
The evidence was a lack of risk assessment, and, well, the land was full of water.
Yep.
So, on probabilities, this was going to occur.
And his last words were, "Get down here, I've been swamped," through the radio.
Shocking. And we see this all the time, viewers. These work sites and workplaces, the employer has a responsibility to ensure the safety of the employees. And if not, well, the company will face a big fine.
But and rightly
look,
so, John.
The next article, Don, ex-cat sues over injury.
Yeah, Matthew Egan played for the Cats in 2007 season, where they went on and won the premiership. Now, before around 22, I believe, John, he injured his foot, fractured his foot.
Yeah.
His club doctor referred him off to a surgeon and said, have surgery, do a bit of rehab and get back. And as it turns out, the surgery didn't go as well as planned. Rehab was too soon. He ended up having 6 or 7 more surgeries and
That's shocking.
ended up his career. So now they're suing the doctor, the club doctor, or he's suing, and the surgeon.
The specialist.
For pretty much failure to warn or disclose what could have happened.
It's a claim for pain and suffering damages. It's a substantial claim, isn't it, Don?
Look, it could be now. He's went on. Lucky he went on to continue working. I think he ended up being
Well, he's currently the
coach.
Essendon assistant coach.
Yeah, it's it.
Essendon. What's happening there? Have we heard from Justice Middleton yet, Don?
Not as yet, John. Not as yet. We're waiting in anticipation for the judgment.
Yes.
But not yet. But in this case, he managed to continue working, so he's not making a claim
So
for
he's
income
suing
loss.
a claim for in negligence, basically saying that the specialists and the doctors, on the balance of probabilities, were negligent in the surgery.
No, negligent in advising of the risks that could follow from the surgery and the early return.
Well, he's had 6 or 7 surgeries after the initial surgery, so something's gone wrong.
Well, I think it's all a combination.
But anyway,
I
that's
think
for
the
the court
case
to
would
decide.
be, and James, if I read it correctly, is that they're saying that had he been warned correctly, he wouldn't have gone back to rehab so quickly. He wouldn't have gone back to play sports.
Well, we'll wait to be seen.
Yeah.
James, harassment happening beyond the office. How can this occur?
This is an interesting matter, John. The federal court has just awarded a substantial damages payout for a harassment.
$500,000.
$500,000. What's interesting about this matter is that the federal court has found that the workplace may be a fixed or moving location. And this is interesting, John, isn't it, in that the work cover legislation seems to be narrowing where the workplace is. Federal court is expanding the...
Well, the federal court has found that the workplace could be a pub where work is being discussed by two colleagues.
And that's what happened in this matter.
Don, what's your take on this story?
Well, it just goes to show that once you clock off, work doesn't finish anymore.
Now, this is a very delicate case. Claudio Vergara has been ordered by the court in regards to sexually harassing Ms. Ewan 4 times in May 2009. The final being she accuses him of actually raping him.
Yes.
But he hasn't been charged.
No, it doesn't say whether it's ongoing investigation or not. But this is it goes to stand that the employment, it's not between the 4 walls of the office. It can go extended. And because it looks like, John, when they've gone out to talk about work, that's where it brings back the work function. I mean, if they went out and had nothing associated with the work, but it sounds like they were there at the hotel to talk about work.
Well, finally, Don, George Pell and his comments about truck drivers and that the Catholic Church is no more legally responsible for priests who abuse children than a trucking company that employs a driver who molests women.
Ludicrous comments, John.
Was this from a comedy script?
I don't know where it's from, but absolutely ludicrous.
I'm astounded, Don. Then he's asked, the relationship between the priest and child is quite different to that between the truck driver and the casual passenger, isn't it? He asked Cardinal Pell. This is the commission chair. And Cardinal Pell has actually conceded that.
Cardinal Pell has probably got the worst media advisor going around,
well,
so that person should be sacked.
What we can say, viewers, is anyone that has suffered at the hands of any institution has a claim and they should seek legal advice. Doesn't matter how long ago it was, because there's always extension of the limitations period of time laws. You should seek legal advice and pursue your claim. After the break, this is a work cover episode. We'll be dealing with the medical panels, how they operate and how they can affect your work cover claim in Victoria. Welcome back, viewers. Tonight we're talking about work cover and the operation of the medical panels. James, what are the medical panels?
John, the medical panels sit within the Accident Compensation Act and also the public liability sphere. The medical panel is a statutory body that is aimed to answer questions of a medical nature.
So they can determine a weekly payments and medical and like expenses claim, can't they, James?
That's correct. If there's a question of capacity for work or whether a particular treatment is reasonable pursuant to the Act, the medical panel can determine on that question.
So traditionally we have a judge that determines a work cover claim in the usual sense of the work cover litigation. But about 20 years ago, James, the medical panels were introduced as a form of basically saving money. It's a cost-saving exercise whereby 2 or 3 doctors can assess the worker's claim and ask questions, Don, of is work related to the injury claimed and what is the consequences of the injury and whether or not medical expenses are reasonable and related to that work injury. So now, in the transport accident laws, we don't have any of that, do we?
So it's only, look, the medical panels are only for obviously the work cover jurisdiction and also the public liability sphere, where in public liability they determine whether or not a person reaches a threshold. In transport accident, doesn't exist, John.
No. Now, there's a sing in the tail, isn't there, about work cover decisions and opinions, isn't there, James?
There sure is, John. Medical panel decisions are binding across the particular question asked before the panel.
So basically, the work cover laws makes it very clear that the opinion of the medical panel is final and binding on the court.
That's correct.
John and James, no, it's a medical question though, isn't it?
Exactly.
It's only limited to the medical question.
The medical question, but the medical question, Don, is pretty wide. One of the questions can be, is the work injury claimed related to work?
And further, they can ask questions about capacity to work.
Exactly. Now, that's been used quite often, isn't it? What's called a 130-week termination.
That's correct.
As in, James, under the Victorian law, work cover laws viewers, anyone that's injured has a right to receive weekly payments of compensation for 130 weeks. And then after the 130-week mark, if they are still not working, then the worker can request an ongoing payment of weekly payments, or unfortunately, the work cover insurer can cease and determine the ongoing weekly payments. Now, that question can be referred to the medical panel.
That's correct, John. So post 130 weeks, the threshold for ongoing entitlement to weekly payments is that you have 0 capacity for work, and that's likely to continue indefinitely. So that does fit within the sphere of a medical question and is often referred to the medical panel.
So if I'm a worker, why would I want my matter referred off to a medical panel? Do I have a choice? It sounds like with the medical panel, John and James, it sounds like, well, this is it. Whatever they determine, you've got 3 so-called independent doctors, which are from a panel.
2 or 3, yes.
Different specialities.
Yes.
And then my hands about whether or not I get payments post 130 weeks or whether or not work cover going to pay or the insurer's going to pay my medical expenses are in the hands of these 3 or 2 people.
Exactly.
So why would I want it to go to a medical panel?
Look, cost-wise, it's very efficient. And it saves the court's time.
So the worker doesn't pay for the medical panel.
Exactly.
So that's purely in the hands of work cover.
Exactly.
Work safe. Right.
Yes.
Right.
And also, if there are issues in credit in play, then that might be a good way for a worker to say, you know what, I don't want to face going to court, being cross-examined in open court. I don't like the idea of that. Whereas I can be examined by 2 or 3 doctors, and on the medical questions, my claim is determined.
But as we'll see in the case we'll talk about tonight, John, that may not happen in the medical panel.
Well, exactly.
So
Exactly.
The medical panel, and James, do we have choice? Do I have a choice? Do I say, I don't want to go medical panel, or this can be referred off by the court, insurer?
Look, it comes down to an assessment of the case on its merits. On occasion, we'll refer to the medical panel because it is faster, it's quicker, it's easier for the client. In other circumstances, we will fix it for hearing, which does take a little bit more time and does require some more work on our part, but it all comes down to the merits of the case.
Viewers, we must be aware that a referral to the medical panel is at the court's discretion. The court refers the matter to the medical panel. Don, the defendant, as in Victorian Workcover Authority, or the plaintiff, as in a worker, can make application to refer the matter to the medical panel, but in the end, the judge, the court, has the final say. And there are times where the court might say, no, this is not an appropriate matter or case that goes to the medical panel. It may be an abusive process, or there may be complex factual issues which does not allow this matter to go to the medical panel, and the judge can determine that. And there's one other point we must be really aware of. This is a decision that's final and binding on the court and on the worker. And viewers, it could, an adverse medical panel decision, as in a decision that says that this is not a work-related injury, can extinguish and cease and determine your claim for weekly payments and medical expenses. Viewers, quickly we can get to the first case of Wingfoot and Kochak, a High Court of Australia case. James, tell us about it.
Thanks, John. This matter relates to a party who sought a determination from the medical panel about work-related injuries. The medical panel found that the injuries the client had sustained were not work-related, and essentially he disputed it through a few different channels. And,
well, James, what was the significance of this case?
There was a number of significant issues that came out of this case. The first being that the defendant in this matter wanted to establish a precedent that a statutory benefits matter, like a weekly payments or medical-like expenses determination, is binding across the whole scheme, in that a failure to find a work-related injury in a statutory benefits matter would mean that they're essentially extinguished your common law entitlements.
So John, they're trying to say what an adverse decision from a medical panel just pretty much affects a whole lot of your claim.
Yes, Don. Look, viewers, we'll get back to this case after a short break. Welcome back, viewers. Tonight we're talking about work cover and the operation of medical panels. Before the break we were talking about the case of Wingfoot and Kochak, a High Court of Australia case. We're talking about its significance on the work cover system. Now in this case, viewers, the Victorian Work Cover Authority sought to rely upon an adverse medical panel decision against the worker and basically try to tell the court that this medical panel decision now destroys the worker's lump sum claim. James, it was a very audacious legal opinion, wasn't it?
It was, John, and it went through a number of different avenues to get to the High Court. But luckily for the workers, the High Court have determined that any medical panel finding, if it is valid, is only binding on the particular question that was put to the panel.
So it relates, for example, in this case, the medical panel opinion found that the worker had no entitlement to weekly payments of compensation and medical-like expenses as the work injuries were not work-related. It was a claim for weekly payments, Don, and medical expenses. But it was not a claim for lump sum compensation. Thereafter, the worker made a claim for lump sum compensation under a separate section of the work cover laws in Victoria. Now, the court virtually found, in the High Court of Australia, that claim can proceed. James?
So it's a serious injury test. So that has to be satisfied for a person to recover lump sum compensation.
Exactly.
And the serious injury test is always been held, John, as far as I'm aware, is always held, it's a legal question, not a medical question.
Exactly. And literally, the High Court found that the medical panel was not the appropriate forum to determine a legal question such as whether or not the worker has suffered a serious injury.
Correct. Well, John, a serious injury test can look at, you either look at level of impairment, which is 30% or more, or if you look at the consequences.
Yes.
And you compare it to a range of possible cases and impairment. So if you look at the consequence, that's not a medical question.
No.
That's clearly a legal question.
A legal question,
Oh,
and it's the narrative test, viewers, and it determines whether or not a worker in Victoria has suffered a serious injury. Now, interestingly, WorkCover have tried this tactic before in the past. There was a case of Pulpich in the Victorian Court of Appeal, which again determined in 2010 that an adverse medical panel decision is not binding on a worker's lump sum claim for pain and suffering and economic loss. In that case, Don, the late Jim Kennan, former Attorney General of Victoria, and I think Premier for a few months before the Kennett government was elected. He was the the senior counsel that fought for the worker in that case.
Can I ask, John and James, you've been practicing this area for years now. How many times have you come across an adverse medical panel decision, but that person or that worker still has access to lump sum because they're determined to have a serious injury?
Quite often, Don.
So
an adverse medical panel decision will not extinguish your lump sum claim, viewers.
So this was a roundabout way of WorkSafe trying to restrict the rights of people and deny their rights to lump sum compensation.
But interestingly, John, didn't WorkSafe actually appeal to the High Court in this matter?
Yes, they did.
They didn't want the binding across the whole scheme.
I think they could see that this had far-reaching ramifications, as in because there are a lot of decisions that are from the medical panel that are in favour of the worker.
That's correct.
And again, the worker could use that
to their
Goes
advantage.
both
to their
ways, doesn't
advantage.
it?
So it goes both ways. And in the end, a serious injury application should always be determined by a judge. However, as we all know, James, even in a serious injury application, medical panels can be utilised, Don, under the Victorian WorkCover laws. It doesn't happen often, does it?
It doesn't at all, but they can make opinion on those consequences, but it ultimately comes down to a judge to make that determination.
Exactly. Well, the next case, James, Moore and Barton, it's a Victorian Supreme Court decision, Court of Appeal, 2014. What happened there?
John, this is an excellent case to highlight how the medical panels can get it wrong and what the avenues are to an injured worker when they do. Ms Moore was employed by Melbourne Health and sustained injury to her lower back during the course of her employment. Her neurosurgeon requested a surgery for her back, which was referred to the medical panel. The medical panel found that the surgery was not reasonable pursuant to the Act, and Ms Moore sought to dispute that. And
they found also that the injury, they found a different percentage of impairment, didn't they?
That's correct. That's correct. It was much lower.
A much lower percentage of impairment. But interestingly, Don, in the Court of Appeal judgment, there was criticism about the actions of one doctor of the medical panel, a Dr. Barton. What happened there?
He's the named defendant. Well, it sounds like there was surveillance film.
Yes.
Which was viewed by the panel. There's 3 doctors, and one of which was Dr. Barton. But in particular, Dr. Barton, in his looked like a one-on-one session with the worker, sat down and went through the surveillance film, which, look, she had a good story. It wasn't a story. She said on a particular day, her back was completely... They were looking at an extreme 3-level fusion, so she had not a good back at all.
And this doctor... Dr. Barton played the video footage in front of the worker on fast forward and did not ask the worker any questions when the film was running.
Well, she says that on a good day, which is it's usually when she takes extra medication, it's usually on a Tuesday where she has enough medication in her system that she can go off and do a little bit more than what she usually does.
Yes.
And obviously that's the day that surveillance was taken. So she had an explanation. But
Yes.
this Dr. Barton would not let her explain anything.
Well-
fast forward,
Yeah.
wouldn't ask her questions, wouldn't let her talk, and just said, "You've watched it."
Dr. Barton would not accept any explanation from the plaintiff while the video was playing. He told her, this is Dr. Barton, that she was there just to view the video. When it concluded, he asked her whether she agreed with the surveillance. The plaintiff did not deny that it was her,
She was
but
the
she
person.
could not see anything wrong with what she was doing. Now, the court was scathing about this. What
Well,
did they, James?
Clearly
And Don.
denied natural justice.
Yeah.
The opportunity to explain was taken away from her.
Yeah.
And there was some weight put on that surveillance film. In fact, that's how they found her level of impairment was much lower, because they said, she shows a bit more movement, because level of impairment is based on loss of movement.
Yes.
They said, show a little bit more movement, so therefore we're going to reduce it.
Well, Justice Dixon criticised the panel's statement that the panel viewed the surveillance DVD in the presence of the worker as, at best, misleading. Now, this, viewers, we're raising this as this goes to show that when you're before the medical panel, you have to be aware that you do have rights. You need to explain how your injury occurred, how it occurred at work, and how it affects you every day. The medical panel will have a stack of documents in front of them, but in the end, the medical panel wants to hear from you, the injured worker, how you were injured and how it affects you every day. And James, what would you advise workers to do?
John, if there's any injured workers out there, be sure to call Newiki Carbone on 1300 Injured. We're there to help and we're there to take your call.
Excellent. Viewers, Don, any final comments?
Look, as you can see, John, the work cover system, all personal injury world, it's very complex, and it's best to get advice. Again, like James said, contact us, newikicarbone.com.au or 1300 Injured.
Thanks, Don. Thanks, James. Viewers, you can catch up on past episodes on YouTube. Otherwise, stay safe and we look forward to seeing you next time.